Fourth essential element of a contract is possibility of execution. An agreement must be possible to get executed. If agreement has no possibility of getting executed, it is void. So in order to make agreement valid, the terms of the agreement must be clear, certain, and able to be executed. An agreement to do an impossible act is void. Let us take an illustration here. A person enters into an agreement with a godman. He chants verses and he says that he can bring a person back to life. So this sort of agreement will be void because this is impossible. Though he has promised that, but it is impossible, as we know, and as the court knows as well. So it will be void, and void ab initio, of course. The fifth essential element of a contract is apparent form of contract. Like according to the Indian Contract Act 1872, a contract can be both oral or verbal or in writing or documented. So contract involving movable property can be verbal, and contract involving immovable property must always be in writing. If you are entering into a contract with a taxi driver, or a taxi driver is entering into a contract, vice versa. So in this case, because it is a movable property, because taxi moves, so that sort of contract can be verbal. And a contract you are selling your real estate property, which is immovable property, it must be in writing. And in this case, we can also observe that we need to follow other laws as well, because if you are selling or buying a property, a real estate property, it needs to be registered, and registration fees or stamp duty duly paid. So you need to follow those rules as well, because if you omit those rules, you do not pay that fees. So in that case, as you have to observe those laws, because in all the agreements, in order to become a contract, you need to follow other applicable laws as well. If you enter into such an agreement when you do not want registration of property with the proper authority, so it will never amount to a contract, because you have created such an agreement where you do not want to register the sale, or you do not want to register the sale deed. So it will be impossible to take it before the court, because otherwise the ownership cannot be transferred unless registered. So it will be improper to proceed in the court of law, and most probably court will dismiss the petition of the person who moves to the court. However, it is advisable, despite we know that in case of movable property, an agreement can be only verbal, but it is better, if you want to claim it in the court of law, it's better that we document it. Either or we can have a video recording as well, because that acts as an evidence in the court of law, of course, so that is acceptable. And then contract must be signed and attested by witnesses and registered if required by law, just in case of this registration of real estate property we observe. So we need witnesses and it needs to be registered. We need to pay stamp duty as well. And we have already taken an example of a movable property movement through taxi. Now, next element, or the sixth element of a contract that is essential, is intention to create a legal relationship. The intention between the parties to the contract must be to create a legal relationship, and it should not be a domestic sort of relationship, like you promise your spouse to give them a gift and later on you do not give, because these are not enforceable by law. And the parties to agreement must make it clear while entering into a contract or an agreement that will later become to a contract, of course, if it is executable by law, that they want to create a legal relationship. It must be clear between the parties. It must be like just in friendship, you say someone, okay, I come to your house for a cup of tea, and then later on you do not go. So these sort of for these sort of petty matters, you cannot claim in the court of law, because it is not worthy of doing that, and it will be too absurd as well. So there must be some sort of legal understanding, and legal relationship must be created, and there must be something like substantial as well. And if any party to contract fails to comply with the terms of agreement, then it will amount to breach of that agreement. Of course, if it is enforceable by law, so in this case it will be breach of contract, and that will give rise to legal consequences, like there can be prosecution, there can be like you need to do something that you do not intend to do as a matter of punishment or as a matter of fine. So like illustration, let's take an illustration here. Like a father promises his son to buy him a bicycle if he scores 75% in his exams. Later on, father refuses to buy his son a bicycle even after he scores 75%. This will not amount to any breach of contract, as it was not intentional to create a legal relationship. It was like personal relationship, son and father relationship. So it was not intentional to create a legal relationship between father and his son. Lawful object and lawful consideration. There needs to be a lawful object and lawful consideration once you enter into an agreement. Now, Section 2D of Indian Contract Act 1872 defines consideration as when, at the desire of the promiser, the promisee or any other person or party has done or abstained from doing, or does or abstains from doing something, or promises to do or to abstain from doing something, or such act or abstinence is called consideration for the promise. Object and consideration of an agreement must be lawful. It must not be illegal, immoral, forbidden by law, or opposed to any public policy. As we know that government issues public policies from time to time, and if you enter into an agreement that violates that public policy, so it will be a hindrance in the work of government. So courts do not entertain such agreements. So this means that such agreements will not become a contract. Consideration means something in return of something, like this means give and take procedure, like what you get and what you give in the ambit of the contract. Like once you enter into a contract, you promise to do something and the other party promise to do something in return. So give and take. So whatever you give and whatever you take is called consideration. And whatever you promise to give, when both agree on the same thing or the same subject matter of the contract, to do or to abstain from doing, so it becomes promise. So the promise is from both the sides. Offer may be from one side, so the person who initiates such a promise, and the person who accepts is the acceptor, but he is also a promiser as well as a promisee. So both are promisers, both are promisee, because after offer has been accepted, it has become an agreement, and once it becomes an agreement, both have promised something, because both have agreed. It is a promise on both the sides now. So both are promiser, both are promisee, and both are giving consideration. So the person who is giving consideration to the other party, so other party is consideration to this first party, and the first party will also get consideration from the other party. So this first party as well as the other party are promisee for each other, promiser as well as promisee for each other. For a valid contract, there must always be transfer of consideration from all parties to the contract. All means all sides of the parties, like if there are 2 sides or 3 sides, so if whatever they have agreed, that must be a consideration, because there are the agreement cannot be unilateral, that we have already studied. It can be bilateral, it can be trilateral as well, or any lateral, any number of parties can be there, but there must be a flow of consideration between the parties. When there is no consideration, then those parties cannot sue each other, because if they have not given anything, then they cannot demand also. So it is a give and take procedure, as we have studied. So there can be any number of parties, but the party, only that party can claim other party from to who this party has given consideration. Because if you are seeking consideration, you must have given consideration as well, or ready to give consideration as well. Now, consideration must be legal. Consideration cannot be illegal. Like you cannot say that you are going to deal in forbidden, like drugs or forbidden arms. So, consideration must be legal. It cannot be forbidden arms. For example, consideration must be adequate. The consideration must be adequate. You cannot say like you want to buy 1 kilogram of gold and you will pay just 1 rupee for that, because that court will observe. Then there will be difficulty in proving that why this much consideration is adequate. Now, in this case, like adequacy has not been defined already. Like some things are already defined. Like in the case of income tax, government issues information on slabs. Like if your income is this much, then you need to pay this much percentage of tax. If your income comes under a higher slab, then you need to pay a higher percentage of income tax. So it is predefined, but adequacy has not been defined anywhere, that what consideration can be adequate, but it is like understandable by everyone. So it depends upon the court of law and depends upon the lawyers, how they present the case and how they are able to prove in order to satisfy the court that the consideration was adequate. There are so many things, so that we learn through practice once we study previous cases, and once we go through the procedures in the court of law. So then we learn these things. And then consideration must be real and substantial. Consideration must be real, like it must really exist somewhere. You cannot say that a contractor will erect a house for you and you will imagine him as a king. So this is too absurd. So you cannot create an absurd agreement, because it will never amount to a contract, and it must be substantial as well, as we have already studied. So substantial will be when it will be adequate. If it is not adequate, so it is like somewhere close to each other. An entity which has no locus in the contract cannot maintain suit regarding the contract. Like if a person has no locus in the contract, no locus means if they are neither party to contract, neither they are anywhere beneficiary, so there is no locus at all. So under no circumstances they can maintain a suit regarding the contract. Consideration must be applicable on the desire of the promisor. Consideration must be applicable on the desire of the promisor means, like you can take an illustration, like a person, like a boy enters into an agreement that he will be selling a real estate property that does not belong to him, that belongs to his father. He might be his successor, but right now the property belongs to his father, and that consideration will not be applicable or not be movable at his wish and will, and as his father owns the property. So this sort of agreement cannot be validated because the son has no authority on the property. So consideration must be applicable or movable at the wish and will of the promisor. So in case if the father had entered into an agreement, that would be a valid agreement and would amount to a contract, because he owns and he can give the property to anyone, but son cannot give the property to anyone else. So in this case, son is not entitled to enter into any such agreement. If he enters, it will not become a contract. Consideration may move from promisee to any other party. Now let's take an example. There was a case where a woman entered into an agreement with her daughter that when she dies, the daughter will pay a specific amount to this mother's sister annually. But when her mother died, the daughter refused to pay her aunt. So because the aunt moved to the court. Now this daughter responded, claiming that as the consideration did not move from the promisee, like her aunt did not give her any consideration. The consideration was given by her mother. But the court observed that the consideration can move from anyone else as well, but the beneficiary must be benefited. So the consideration may move from the promisee to and for any other party. So the promisee was the aunt, because aunt was promised to get, and this promisee moved to the court, and in this case promiser was the daughter, and daughter failed to fulfill the promise, but the consideration may move from promisee to any other party. So in this case, as a party to contract was mother also, so she was also a promisee, and on the part of daughter she was also a promisee. So in this case the consideration moved from promisee to any other party, this consideration moved or to any other party also means on behalf of any other party. So the mother paid the consideration on behalf of a sister, and who was her daughter's aunt. So in this case the consideration may move from the promisee to any other party. So in this case the consideration moved from the promisee, who in this case mother was also a promisee, because both are promiser as well as promisee. So moved from the promisee for the other party, who was her sister. Both the parties to agreement, or all the parties to agreement, receive something valuable in return of promise. There is the concept of materiality otherwise as well in all the cases. If there is something materialistic, then you move to the court. If something is not substantial or it's of very little value, like say a matter of 1 rupee or 2 rupee or 50 paise, and you move to the court, so it will not be viable. So court may dismiss such a petition that it is not workable. Though it's a matter of court, you can make your stand, you can prove it prove it a matter of dignity as well. So there are so many things in the court and in the law to consider. So that's another thing. But as a general rule, we can say that if there is something not materialistic or not valuable, then it is not workable or not viable. Consideration must be lawful, that we know. There can be no contract without consideration, because consideration is the most important element of a contract. There must be a consideration, and that must be a legal lawful consideration. Any agreement which has unlawful objects or consideration will be void. Section 23 of the Indian Contract Act 1872 lays down certain types of considerations that would make a consideration and its objective unlawful. Consideration should not be forbidden by law. Consideration should not be of such nature that it is not allowed by law, or it will defeat the provisions of law under any circumstances, or is fraudulent. Now, if consideration involves or implies injury to the person or property of others, so this is also not acceptable. The court regards it as immoral or opposed to public policy, then also it will not be acceptable. We can take an illustration. A man promises to sell his truck to a woman for 1 lakh rupees. The woman promises to pay 1 lakh to the man. This is an example of a valid consideration. Now a man enters into an agreement with a woman to sell legally forbidden narcotics material in exchange of 19,000 rupees. So this is not a valid agreement, because the object of the agreement is unlawful, and the consideration, that is narcotic material, is also unlawful. So under these circumstances, such sort of agreement will never become a contract. Now, the 8th important element, or the element of valid contract, is competence to contract. The parties to enter into a contract must be competent to contract. An agreement with a person who is a minor is void ab initio, like since initial stages, since its inception it's void. Section 11 of the Indian Contract Act lays the following condition to specify competence of parties to contract. Now these conditions are like let's study in the case of minors. Competence to contract in case of minors. Parties to contract must have attained the age of majority, that is above 18 years in normal cases and 21 years if guardian is appointed by the court. Minor is not competent to contract. Contract by a minor or with them is void. A minor is incompetent to become a partner in a business firm. A minor can be a promisee or a beneficiary. Like some people enter into a contract in the benefit of their sons or daughters or any relative. So though the minor cannot become a party to contract but can become a beneficiary after all. And an agreement by or with minor cannot become a contract when they attain the age of majority. Like if you enter into a contract with a minor and that time it is void, but later on when he becomes major, you cannot claim that now you have become major, now it has become valid. So it's void ab initio. So when it was void ab initio, it cannot be validated now as well. A minor can act as an agent and bind their principal by their acts without incurring own personal liability. So there can be cases where a minor can act as an agent, but they have acted as an agent, but as they are minors, they will not incur their personal liabilities. But as they are working on behalf of their principal, it will be liability of their principal. Like illustration is A enters into an agreement with B, who is a minor, to sell his bracelet. This is not a valid contract because B is a minor, and even if he agrees, so that this agreement will not become a contract because he cannot make sound decisions and his age is not considered to be of such maturity that he can make decisions considering his interests. So he may hurt his interest and he can easily be misguided. Now, mental ability of the parties to contract. Parties must be of sound mind while making the agreement. A person who is usually of unsound mind, but occasionally their mind works properly. So in this case, if they enter into an agreement only during the time where their mind is working properly, that this agreement will become a contract. And there are those people also whose mind